So this afternoon session is on the dissolution of the wardship regime, and it's a critical analysis of that. So obviously we've been talking about this quite a bit for the last couple of days in terms of the slow pace, what that means. So we're going to be joined by, Mary Donnelly is going to kick us off, and we're going to be joined online. Unfortunately, for personal reasons, Mary Claire Butler couldn't be here, but we're absolutely grateful to her for pulling out all the stops to be able to record it online this morning. So we're really grateful. Mary Claire is also online with us. So she won't be able to do the questions live, but she'll be able to answer them hopefully through the online kind of mechanism. We also will have Selena Doyle, who comes from Aurora Enriching Lives, and she'll be speaking shortly. And then we're also going to be joined by PJ Herlihy and Michelle Angeland, and PJ might even come up at the end, but we'll see. We'll see how PJ feels about that. Okay, brilliant. So to hand you over to Mary. So Mary, off you go there. Thank you.
Thanks very much. And I think can you hear me? Super. Elaine runs a reign of terror up here, so I will do this properly and not find myself. So here we're talking about filling the wardship gap. So if we begin and think a little bit about what the Act does and then what it doesn't do. So what it does is it discontinues new applications for admission to wardship from the 26th of April of 2023. What it doesn't do is make provision for the authorization of deprivation of liberty. It doesn't provide for a framework for end-of-life treatment decisions, although it does require that if an application is being made in respect of them, it must be made to the High Court. And it doesn't provide for safeguarding actions outside of the support framework in the Act. So that kind of broader safeguarding vision isn't covered. Thus, we end up with the wardship gap. So briefly, and I think we kind of all know this, but just to kind of remember why, in particular, this issue of protection of liberty is so important. And why the wardship gap in that space in particular has been so problematic. So if we go back to the decision of the European Court of Human Rights, and as you all know, the European Convention on Human Rights applies directly in Irish law. We have to apply it in our courts. So from the decision of HL versus the United Kingdom, here we had a man living with a foster family, an adult living with adult foster parents as an adult, with foster parents as an adult. Autistic, he was autistic, he was nonverbal. He went every day to a daycare service. One particular day he became agitated and he was removed by ambulance to a psychiatric facility. And there he stayed. There was no legal process by which he was admitted. His foster parents weren't allowed to visit him, and he was not allowed leave. Now, this case is interesting because he never tried to leave. The service was clear. If he had tried to leave, he would have been stopped, but he never actually tried to leave. Through an enormous amount, and one has to have so much admiration for his supporters, they managed to bring a case arguing that this was a deprivation of his liberty. He was being held without any process. They managed to bring a case all the way to Strasbourg. And any of you from any background can just imagine how tough that would be. The European Court of Human Rights said he was deprived of his liberty and there was no process of law. And they said, the court reiterates that the right to liberty is, and I've bolded up some letters here, too important in a democratic society for a person to lose the benefit of convention protection for the single reason he may have given himself up to be taken into detention, especially when it is not disputed the person is legally incapable of consenting to or disagreeing with the proposed action. In other words, if someone is held in a place and they have not consented and there is no process of law, that is a deprivation of liberty, and it's contrary to the European Convention on Human Rights. The issue, now, to be honest, for the first while, you'll see that's a 2004 case, for the first 10, 12 years, there wasn't a lot happening in the Irish courts around deprivation of liberty. However, our deprivation of liberty case came in 2019. A case out of Cork called AC versus Hickey. Mrs. AC here was in hospital. She'd come in with a broken hip and came back shortly afterwards with having gone home, came back with her other hip broken. She was in her 90s. She had dementia. Her capacity was in question. Relations between Mrs. AC's family and the hospital were not good. At a certain point, Mrs. AC said she wanted to go home. So she clearly articulated a desire to go home into the care of her family. She said it, and she subsequently wrote it. But the hospital were concerned that this would be dangerous. She would be at risk if she left. So they held her and did not allow her to leave. 2 weeks later, they made an application to have her admitted to wardship, and she was subsequently admitted to wardship. The case raised many, many issues, but the one I want to concentrate on today was what was her status during those 2 weeks when she wasn't allowed leave. The court found that in the circumstances she wasn't unconstitutionally deprived of her liberty. They found that there was a right or a possibility of the hospital to hold her for, and you'll see it there on the bottom, a brief detention in order to get the matter to court. However, they said anything longer than the detention in question, which was I was about to say which was 5 minutes because Elaine is showing me this time, which was 2 weeks, was potentially a deprivation of liberty. And they said, when you're looking at this, you ask, does the person truly want to leave? If she truly wants to leave, and Patricia mentioned this earlier, and she has capacity, she is free to go. That is the end of the matter. If she lacks capacity, the hospital has no general right to hold her. They need to employ a legal process. And of course, that legal process was wardship. But now, of course, wardship is gone. So what do we have instead? We have something called the inherent jurisdiction. And Roisin mentioned it, I don't see Roisin, but Roisin mentioned it earlier, saying this is something, a term she'd never heard before, and an awful lot of people, I think, would be in that boat. It was a term people didn't hear. So what is it? It's an implied power of the court, exercisable by judges, and as Judge O'Connor just pointed out to me, I should have said there, it's an implied power of the High Court, exercisable by judges. The Circuit Court doesn't have that authority to make decisions in the interest of justice where you don't have a statutory regime. Nice quote there from Mr. Justice McKechnie in the Supreme Court. He describes it as an ill-defined and unregulated territory. And that's from 2021, that's not from the Dark Ages. So this is the solution. This is the only solution to fill the wardship gap. And it's being used liberally. Well, when I say liberally, it's being used, and it has to be used as it's the only option. So you'll see there some of the data, and I'm grateful to the court service who have provided us with this data. So we had 78 inherent jurisdiction applications in 23, in terms of total cases, up to 152 in 24, and then the total number of orders, because you might have a number of orders in relation to the same person. So somebody might have an order for a deprivation of liberty, and they might have an order regarding where they live, and they might have an order regarding treatment, and then they might come back again to have their orders renewed. So you could have a lot of different orders for the same person, you see again then that increase. 284 in 2023, 651 in 2024. Most common applicants are the HSE and the Dublin hospitals. And some of you mightn't realise this, to be perfectly honest, I didn't until recently, that the Dublin hospitals don't make applications to court through the HSE. They have their own, they make their own separate applications. Most common basis, nursing home admission and once-off treatment decisions. So that's where the inherent jurisdiction is being used. Such is the busyness that we've got a new practice direction on the inherent jurisdiction. There's a list which is sitting every day at 10 a.m. Applications are heard by the president or a nominee, and there's provision for an immediate hearing of very urgent ex parte applications. And I think anyone, from what I hear from people who've been using the service, the courts are really pulling out the stops, particularly in emergency situations, because sometimes these can arise and you literally have no option but to go to court. In terms of hearings, and here I haven't done a systematic review, but I have heard from people who are using the inherent jurisdiction. So it is based on empirical data, but I can't pretend it's systematic. But things we're seeing, voice of the person is very central, and that I'd imagine is no surprise to any of you who have heard our two judges from yesterday. That centrality of the voice of the person is there. The other thing we're seeing, and this is one kind of which we're not seeing in any of the other aspects, or any of the aspects of the Act, we're seeing the use of guardian ad litem. So fairly routine use of guardian ad litem, making significant efforts to ascertain the person's will and preferences. We're also seeing remote attendance being facilitated, and again, both Judge O'Connor and Judge Heslin spoke of that yesterday. And we're also seeing the application of the ADM principles. So the court is using the ADM principles to make the decision, albeit that it's under the inherent jurisdiction. That really isn't sustainable. It's not, in a sense, able to continue. So we do need to develop frameworks which can more effectively, whilst it's very effective for the person who can get to the court, the inherent jurisdiction application that gets to the court. There are people who are not, their cases are not making it to the court. So, as Patricia said, we are in the process, and have been for a long time, of developing protection of liberty safeguards. We did a consultation paper back in, I'm saying 2018, Patricia said 2017, I'm sure Patricia's right, she always is, but we're expecting a new consultation paper next year. And then the other thing, and again, Patricia spoke about this, I'm watching that bell, and I'm daring her to ring it. Patricia spoke about this. The Law Reform Commission produced a 1,000-page report setting out what we need for adult safeguarding. If that legislation happens, and we have to look to the programme for government to see what will happen, that may also address some of the challenges in this space. But we definitely need to do something to develop our alternatives to the inherent jurisdiction. Thank you.
Thank you for, I think it's fair to say, it's a very complex area, but setting it out in a way that's accessible to most of the people in this room won't necessarily have had much dealings with the inherent jurisdiction, so I think it's really important, and it's really important that people have the chance to try and unpack it in some shape or form, and I think we'll probably do more on this as well the further we kind of get into it. The next person that I'd like to welcome is online. So we have a pre-record from Marie-Claire Butler. Marie-Claire is the General Solicitor in the Office of the Wards of Court, and Marie-Claire's principal job is to enable the transition of people from wardship under Part 6 of the Act into out of wardship. Well, everybody comes out of wardship completely, and then if they need a new arrangement, that is part of that process. So Marie-Claire is going to kind of bring us through that. I know people have lots of questions, so Marie-Claire has tried to address some of those but also she will be online. You won't hear her online, but she will be online to address some of those questions. So if you have questions now, she is with us at the moment. She can see and hear us. So over to Marie-Claire. Thanks, Jacqueline.
Good afternoon, everybody, and it's great to be here. For those of you that don't know me or aren't familiar with our office, my name is Marie-Claire. I am the General Solicitor for Minors and Wards of Court, and I'm an independent committee appointed by the President of the High Court in certain wardship cases, and my office is within the court services. So I'm here to talk to you today about Part 6 applications and discharges from wardship, and just speaking from a position of experience with some of those at the moment. So as everybody knows by now, the ADMCA commenced on the 26th of April 2023. And for wardship, that meant that the old system of wardship was to be phased out. So in broad terms, all adult wards of court are to be reviewed and discharged within 3 years of the commencement of the Act. So in other words, on or before the 26th of April 2026. So just to give people who may not be familiar with Part 6 applications an overview of the process. So it starts life as an initial application filed by a solicitor with the Office of Wards of Court. That document is called a notice of motion, and that notice of motion triggers the attendance of the medical visitor on the relevant person. Now, the medical visitor will attend with the relevant person at a time and place that suits the relevant person. And this is to undertake a functional capacity assessment across the key areas of the 2015 Act. So after their visit, they'll prepare a functional capacity assessment report. And that report will be sent out to the applicant, but also sent out to the relevant person for their consideration. At that point, a grounding affidavit, so that's a document that contains all the information the court needs to know, that's prepared and filed with the Wards of Court office. And at that point, the papers are then served on the relevant person by a solicitor. This service allows the relevant person the opportunity to discuss the application with the solicitor, what it means for them, the outcome of the medical visitor's report, and to discuss their will and preference around a decision supporter. After that, an affidavit which details that service of the papers is prepared, and that's lodged with the court's office again. And once the court is happy that all of the relevant matters have been attended to, it fixes a court date for the discharge review hearing. Once that date is known, then the solicitor will attend again with the relevant person and serve those papers. Now, the purpose of this second service is obviously to let the relevant person know the date of the hearing. It's also a really important opportunity to canvass will and preference again, particularly around decision supporters. And it's also an opportunity to encourage the relevant person to attend their own discharge hearing. So after that, the court papers are prepared and the judge reads everything in advance, and the hearing then takes place. So in terms of the review hearing, you can see on the slides there, I have the outcomes and capacity declarations that can be made. So the first one is the relevant person has capacity or is recommended to have a decision-making assistant. Now, these are treated one and the same in terms of discharge. So essentially, the relevant person will be discharged from wardship to the management of their own affairs. The second outcome is having capacity with the assistance of a suitable person as a co-decision maker. And that person is identified by the relevant person and the hearing takes place, but the discharge from wardship is contingent on production of the proof of registration of the co-decision making agreement with the DSS. And you'll see there at the bottom that if there isn't anybody suitable to act as a co-decision maker, it is possible to have a DMR from the panel nominated, but they must endeavour to act jointly with that relevant person. The third outcome is does not have capacity even with the assistance of a co-decision maker, which means that the relevant person requires the assistance of a decision-making representative. The decision-making representative is ultimately appointed by the court, but suitable people can be identified by the relevant person in advance of the hearing. And again, if there's nobody suitable to act, the DSS have a panel from which nominations can be obtained. You'll see the final slide I just allowed for mixed outcomes because, as you know, capacity across different areas can vary. So there is obviously the strong possibility of mixed outcomes in a review hearing. The next slide is just a reflection on what is important to the court in my experience so far. And the number one thing that the court wants to see is engagement with the relevant person. And it's really important for the court to know their will and preference. The court really wants to hear the person, so hear about the person and hear from the person, hear their voice. They'll hear it through the paperwork, as I've mentioned, through the services. They can hear it through other means, like through a letter from the relevant person, or by talking to the relevant person during the court hearing. It's really important to the court to know who is a potential decision supporter and if they are willing to help, and importantly, if they understand the responsibility. It's also important to the court to hear from anyone with an interest in the person, including family, advocates and professionals and carers involved in the life of the relevant person. So this is a journey, it's a 3-year journey, and let's take a look at where we are so far in that journey. Just some numbers to consider here. So we're over halfway through the 3-year period allowed for in the Act for the review and discharge of all wards of court. As of last week, there were 1,918 active wards and 341 discharge applications in progress. So far, 92 wards of court have been discharged. More than 80 of those have been discharged by my office, and you'll see the figures there around the categories of discharge. So we have 19 people so far discharged to the full management of their own affairs, which is wonderful. We've had 4 discharged with a co-decision maker and 73 discharged with a decision-making representative. The Wards of Court Office helpfully undertook a survey of committees in May and June of this year, and they actually undertook a very recent one again in November, but I don't have those results to hand just yet. But back in May and June of this year, 97% of committees were aware of the 2015 Act, which is great. Equally great is 95% were aware of the requirement to discharge within 3 years. And at that stage, 57%, so well over half, had discussed it with the person who they act for as committee. 53% had contacted the Legal Aid Board or a solicitor for assistance. So that's all great. However, there does appear to be a little reluctance on the part of committees to proceed. So when you go back to my previous slide, you'll see the number of active wards versus the number of discharge applications so far. So according to the survey, there's a few key points that committees are a little bit concerned about, which speaks a little bit to the reluctance to proceed at this point. So first of all, some people are just happy with the current system and they can't see any benefit from moving. Now, that cohort tends to be people who represent elderly people in nursing homes, or perhaps where there's a large payment being managed by the court. We have to look at this through the lens of the committee, though, and the relevant person may, of course, have a different view on that. Some people want to see how the first ones work out, which is a natural reaction to change. And then the 2 last ones are the ones that seem to come up most often, and that's in relation to cost and investment of funds. So we might just take a little look at those further. So you'll see on the screen there's some quotes from directly from committees from the survey in relation to the areas of cost of the application. And you'll see people are concerned about paying twice or that the costs remain unclear. So what are the assurances that we can look to around this? Well, first of all adult wards are eligible for legal aid for discharge applications. Now, there is a provision for clawback on a means test in the future, but no regulations are enforced for this clawback as yet, with 17 months to go on the time allowed in the Act. So I think that this is causing maybe people to be a little bit hesitant because they want to know whether or not those regulations are being brought in, and certainly it probably speaks to a little bit of nervousness around that. Really helpfully, legal aid is available to assist with co-decision making agreements. So that's really, really helpful because that agreement does require a little bit of work, and it's wonderful to have the support of legal aid around that. Legal aid is also available to assist with second opinions on capacity. So where you have a relevant person or an applicant who aren't happy with the outcome of the medical visitors reports, they can seek a second opinion via legal aid support. A few more quotes from committees there about a little bit of nervousness again about the responsibility with making choices in relation to investing of funds. People wanting to wait until the deadline and want to see how they can invest the funds that are currently held in court. So again, just a couple of points around that. There are plenty of financial advisors, I'm sure, out there who would be delighted to talk to people about investment of funds. If committees are reluctant to take on the investment piece around large sums of money that are currently with the court service, which will be paid out on discharge, it is possible to seek a financial DM or a professional person from the DSS panel. So that's something to consider, which might mitigate that fear. Change is difficult for everybody, so what I've said here is just reach out and talk to all professionals involved and get all the advice you can if you are worried. And don't be in the stampede at the end, because there are a number of applications to get through, and it'd be better to do it sooner rather than later. Briefly, just a reminder of who can apply. So Section 54 of the Act tells us that the relevant person or the committee, of course, can make discharge applications. But very helpfully, with the consent of the court, somebody who is in a position of trust with the relevant person, like a relative or a friend, or somebody with an existing relationship or expertise, so that could be an advocate, can apply to the court for permission to bring the discharge application. So just some final thoughts after that whirlwind tour through Part 6s. It's really, really, really important to recognise the right of a person to be discharged from wardship. And I'm saying that particularly to committees out there who might be a little bit hesitant. To advocates and to professionals that are working with relevant persons out there, do what you can to support them to move forward. Contact the Legal Aid Board, assist them in gathering their information if they want to bring the application themselves, or if you feel that the circumstances would apply, consider yourself asking the court to allow you to bring the application. And finally, I've said there, it's good to talk, and it's very important in the context of these big steps forward from wardship to assisted decision making. So I'd encourage all committees to talk to the people for whom they act, to the relevant persons and their advocates, talk with each other, talk to the professionals involved, and see how you can move forward to bring the application, but always remembering that the person is front and centre of everything we do. Thank you very much.
Thank you very much to Marie-Claire, particularly for her personal circumstance, for being able to get that done today. I think it's a very, very accessible kind of presentation on what the whole process is about. I would say, particularly for those that are online, Marie-Claire is also online, so if you want to put in your questions, she's available to respond to those, so please do let us know. So now we're going to move into the practice of supporting somebody to exit wardship, and we have Selena Doyle, who's the Director of Strategic Development in Aurora Kilkenny, and she's also a social worker by background. So Selena's going to walk us through, particularly for those practitioners that are wondering, what do we need to do? I know numbers of people who are wards that are in my service, what can I do to support them? Or people here that maybe know somebody who's in wardship and wants to have an idea about what the process is involved. So Selena's going to step that out for us. So thank you, Selena.
Good afternoon. Aurora Kilkenny is a disability service that supports people who, in the main, had a lifelong intellectual, physical or sensory disability. And in terms of the Act, we've strongly welcomed the Assisted Decision Making Act 2015. And since then, we've been working to align our policies in line with the principles of the Act, not just our policies, our procedures and our practices going forward. In 2017, we met with the families. We have a family forum that is independently facilitated by Inclusion Ireland. So it's been a live topic for that long. We also addressed next of kin. In essence, what that meant was we stopped asking families to sign consent forms for people to do things. We stopped sending out bank statements. Now, that was not to the exclusion of families, because what we did was create a circle of supports around the person, and the family members, if the person wanted, was part of that circle of support around decision making. But this was not new news to the families that we support in Aurora. We have an ADM Leads team, and we're responsible to guide our staff in relation to the guiding principles of the Act, and we have oversight of any ADM cases. So this team agreed to proactively support people who are wards of court to seek discharge of same as soon as possible, on the grounds of least restrictive principles, so moving as far as possible away from substituted decision making to supported decision making wherever possible. All 5 people, all of their committees are family members, which I think is quite unusual. So what we did was the social worker met with the relevant person and their existing committee with regard to discharge. and the committees themselves were all, for different reasons, nervous about triggering the process themselves. So some people just wanted the status quo to continue. One committee member had concerns around finances and how much it would cost. And then we have another committee who are elderly parents in their 80s, and the whole thing was just overwhelming. So we decided to support the person in their own right to seek a discharge, and we made application on their behalf to gain civil legal aid. In doing so, then we developed some easy reads and spent time with the person going through this, and we did then get the panel of relevant solicitors who would take on the cases, and we went through that with the person. In terms of the easy reads, so the person did not sign any document with legal aid. What we did was went through the easy reads with the person and then sent that back to legal aid to state that those had been shared with the person on this date. So there was no signature of anybody to say that we were signing on behalf of, and that was accepted by the legal aid board. In terms of a particular case, so I'll just go back though, the solicitors, we have one solicitor covering 4 cases and another solicitor for the 5th case. The lady who's supporting the 4 people, the solicitor came down to meet with the person, each relevant person in their own home. And that was over the weekend, and it was at a specific time, so we were really careful around what that appointment would look like, what relevant information we needed to have to hand, how we were going to support the person, what their conditions of success was, what their communication method was, and how they were going to engage with the solicitor. So a lot of detailed work went in before the meeting took place. So just a case example, P is a gentleman who's 46. He lives in his own home in the community, which is a designated centre, and we provide residential supports. He shares his home with 3 other people. So a number of years ago, P was made award of court to provide support in the management of a significant financial award as a result of an accident, and his committee is his sister. P is able to express his will and preference in everyday decision making using intonation, expression, hand gestures, body language, but he does, however, need support with regard to managing his money. P is a gentleman who underwent a process of decongregation along with the other 80 people that are all the supports within a 4-year period from 2016 to 2020. And since decongregation, we've been able to see very strong evidence base of how people now can make many more decisions than we previously thought. There's always that potential for diagnostic overshadowing with people with complex intellectual disabilities. And to that end, we feel that was the same case with capacity, that assumptions would be made with people with lifelong disabilities that they wouldn't have capacity. But our evidence shows that they can and will, with support, make many more decisions on a daily basis. And that was the case for P. He was making many more decisions in everyday scenarios. So once we'd established the solicitor was able to take his case, as I said, she came down and met with him. We made sure our staff were rostered who were familiar to him and to enable us, as best we could, effective communication. As P is the moving party, he's required to sign the grounding affidavit. However, given his capacity, this is an issue, and the barrister is now filing a motion to the court seeking direction as to who will sign the affidavit. So that's where we are at the moment with the 4 cases. When the medical visitor comes to visit with P, the service will ensure we share the relevant information we have regarding his communication method and his conditions of success regarding his ability to engage, along with the evidence that we already have about what decisions he can make. Upon submission of the medical visitors report, the judge will then make a determination as to who can sign the affidavit, and the process will then continue regarding his discharge from wardship and any provision required under the ADM. So, other considerations. As a service then, so I know lots of services are very reluctant to support the relevant person to trigger the discharge application. And a lot of that, from what I've heard from other services, is due to the costs, really. They are worried if they become the moving party, then they will have to have legal teams costs incurred. But as the relevant person is the moving party, that is not the case. The legal aid certificate covers that, and so services will not be left with the bill, so don't let that be something that puts you off supporting people. I know that doesn't apply then if you're with a committee, because the legal aid certificate is for the person. What we did was refer all relevant people to the National Advocacy Service for the appointment of an independent advocate. That's very important because as a provider we have a service position and we understand P on a certain level, and the family would also understand him on another level. It's very important to get somebody independent in to stress test that and see and meet with the person themselves. We've also referred the relevant people and their committee to the NDA research piece that Dr. Caroline Nolan has carried out, and she's been down and visited all the relevant people and their committees, and 3 of which are engaging in this research. So some challenges for us was that we were uncertain about whether we should or shouldn't trigger this. What was it going to look like? We weren't really clear on the pathway when we did the triggering of the application, but we were very committed to supporting people to move out of wardship and then get an alternative if required under the ADM, under the least restrictive principle, especially as people have been able to display to us their abilities around making decisions. So we've had resistance from one committee. They have been very reticent in accepting that the relevant person can have their own legal representation. We'd followed the same process, referred them into legal aid, and the committee cancelled those appointments, stating that their representation, their legal solicitor, was going to do the representation. That took a bit of wrangling. We went back and forth with the Wards of Court, and eventually the committee have accepted that, and this gentleman now has his own independent. That's not P's case, it's a different case. However, we as an interested party have relevant information because we've had concerns regarding rights restrictions for this gentleman as the committee manages significant financial assets that he has. And before that we've liaised with the Wards of Court around those concerns. So during the process of him meeting with his legal representation and with his advocate, we will make sure that that evidence is available and will then be presented into the submission. Another challenge is pace. So from the time we started this to where we are now, we seem like we haven't got very far, but there was a lot of work to do and a lot of figuring out and sorting out and working with the person and the committee, as I said, developing the easy reads, the paperwork, etc. So that has been a bit of a challenge. In terms of, I suppose, what's really relevant to us is around the people that live and are supported by Aurora have never chose to live there, and so the protection of liberties is going to be really key for us. There are people who came into our service as young children and have continued to live with us into adulthood, and I don't think anybody's ever asked them if they choose to live with us. Their frame of reference of where they may choose to live is very limited because they only have the concept of institutional living. So I think that what's coming down the lines in terms of protection of liberties will be very helpful to guide us with that regard.
Thank you very much, Selena. And I think that was, for those that were here last night that heard Judge Heslin, I think that's a very good, it's the other half of the story that he talked about, and about that the whole back work that has to happen before you actually go to court. So I think that was really important. So now we are absolutely thrilled to have PJ and Michelle Angland from, just hold on a second, I got my papers, from Kerry, formerly hung out in Cork, but we'll tell you that yourself. And I'll let Michelle introduce PJ. But PJ is in the process of leaving wardship, so he wants to talk to us about that. So thanks so much, PJ.
I'm delighted to be here today with PJ. PJ and I are both part of St. John of God Service in Kerry, and we have been working together trying to navigate the steps and build both of our capacity on being discharged from wardship. So PJ is going to introduce his video where he very kindly explains to us his journey to date and all the challenges he's faced in his life so positively, and I think you'll see how positive he is about being discharged and his hopes for the future. Thank you.
My name is Peter Halliday. I'm delighted to be in today. The water court. To great to be here. Meet lot of people. Delighted to come to court. To come to court.
「 Hi, my name is Michelle England. I'm Assistant Decision Making Coordinator in St John of God Curry Service. I'm delighted to introduce PJ Hurley, who is a ward of court, and PJ has very kindly agreed to tell us his story and how he has found the process of being discharged from ward of court.
PJ's committee is a solicitor based in Dublin.
My name is PJ Hurley. I sit in tree. I was born in not in Gaza. I got no. I always try. I got no brother sister. I said the dog with people. I moved back to training 2003. I got my own department. I work in Gab. I like it. So I like it. With a lot of people.
PJ, can you tell us how you became a ward of court?
I was knocked out 1997. The car crash. I go to court. I got money in court. I got money out to crack the court. That moved back to the. I was knocked out. I got money and they got to court and did. I got money out the house, the farm in that got 1997, and that moved to Dublin too. And all my money in Dublin. I want money the sa for the solicitor for the sa and the what the solicitor sit down the money to me. I could form myself one sat for I did. I could get my money for kills, put my feather, go the hotel, kill on the by something like from my girlfriend. Or the kill, something like that.
So PJ, we're trying to support you to understand what it means to be discharged from wardship. So we have some easy read material developed for PJ to understand what steps are involved in the process.
Information is given to PJ in a way he understands and in line with his assessed communication. He is met at a time and place that suits him, and this aids us support PJ to build his capacity and understanding.
I sat and be a shop for court, and a man called to see me. He talked me about my money, my air pub, for the next step,
PJ will explain a second visit from a medical visitor who carried out a functional capacity assessment.
A man called to me. He do set with me. He talked to me. He made something for St John got. But my money. If I go to the fruit.
Following assessment, PJ will require the assistance of a suitable person as a co-decision maker in managing issues relating to his health, his welfare and financial matters.
PJ, what are your hopes after being discharged from wardship?
Oh, I got no more to do with it. Get someone to get my money. I need to get my money. No more double. Maybe someone. They knew what. Get to my money. They knew what me. To my money. I ought to go to court myself. I don't know all I to say. I ought to be there myself. I said. That man was too late to me. I drive with it's very good.
I think PJ needs another round of applause. It's very hard to say anything after that. That was beautiful and really important to see what's important to you and your girlfriend, and get back to Kerry and being able to go out and have a regular life. So I think that's really terrific, and thank you so much for doing that, and thank you so much, Michelle, for taking the time to support PJ to do that. So I think, you know, I suppose it tells the story that we don't hear, and this is what this conference is all about, is remembering that there's a story behind all of this stuff. So and the same with Sarah Jane earlier on, you know, brilliant stories, and thank you so much for sharing your stories with us. So so that brings this session to a close.